What is going on, guys? My name is Mark Reel, the host of the Father's Rights Playbook. And today we have managing attorney of Real Father's Rights, Ryan Dreyer, on the show to discuss everything Trevor Bauer and the average man defending himself from false allegations in family court. On to the podcast. All right, Ryan, how are we doing today?
Doing great. How are you doing?
Good. So, interesting topic today. The news of the Trevor Bauer issue broke last week. He released a video. Some information was hidden from him throughout the process. And I think for the type of clients we represent, it's really, really relevant to talk about what Trevor did, what Trevor went through, and how the average man who isn't worth 8 figures can defend himself from these allegations.
Absolutely, yeah.
Yeah, so the first thing, I'll give a little bit of background on the Bauer situation. So Trevor Bauer in the summer of 2021 was accused by a San Diego woman of sexual assault, that a sexual encounter had turned non-consensual. She filed a domestic violence restraining order. Bauer and his legal team, over a multi-day domestic violence restraining order hearing in family court in Los Angeles, a restraining order was denied. Immediately following that, Trevor filed a civil lawsuit, and it's come out over the past couple of weeks that the attorneys for the accuser withheld information during the discovery process of the DVRO. So, Ryan, for all of our listeners, for our viewers, walk us through when someone calls us up and says, hey, I just got served with a restraining order. What's usually going on? What do we do in those first steps?
Okay, well, in the first steps, we need to figure out what's at issue. Are you a father, first of all? Is there a child involved on that restraining order? If there's a child involved on the restraining order, it does change the dynamics quite a bit. Now, Mr. Bauer didn't have a child with this woman. Thank God, right?
Interesting argument they made in this trial as well. They made the argument that she did not fit the definition of an individual that could get a domestic violence restraining order.
Interesting.
Yes, so one of the arguments Bauer's counsel made, to get a domestic violence restraining order, you have to essentially be family, be some sort of close relationship. They actually made the argument that based on just 2 sexual encounters, that she did not meet the burden of being an individual that could even get a restraining order against him.
Interesting. And if you can get rid of a domestic violence restraining order based upon a procedural element like status, right? And so basically saying they were never in a dating relationship and she's not a former girlfriend or fiance or wife, right? If you can get rid of them that way, absolutely do that, right? The rule of law is if you can get rid of something on a procedural element, you do that first. If you can't do that, then you pound the table with the facts, right?
That's a big one because the burden of proof. Walk the listeners through the burden of proof and why winning on a technicality a lot of times is the best.
Well, absolutely, because the standard of proof in a domestic violence restraining order is preponderance of evidence. Preponderance of evidence is our lowest standard, more likely than not. So this allows when there's a he said, she said credibility determination, if the judge finds the accuser to be 51% more credible, you can get a restraining order granted. You can get a restraining order granted without pictures, without police calls, without text messages. It's crazy how low the standard is. If we look at other restraining orders, you have a clear and convincing standard of proof, which is much higher, and it's still below the proof beyond a reasonable doubt standard. So you are going in every time, and you're gambling that judge is going to find you credible and find the other party not credible.
Yeah. I think the big piece for me, and I always tell our clients this, is the fact that the judge is safe granting a restraining order. The judge can lose no sleep. That nothing bad can happen to the judge for being aggressive and issuing restraining orders. Whereas if they deny someone's restraining order and then later that night something happens, guess whose name is in the paper? It's the judge. It's that the courts, that the legal system wronged this individual. So it may be 50% in one feather can get that restraining order granted, but I would argue in practicality, it's probably even a little bit lower than that.
I would say so too. There is almost a feeling when you're defending a domestic violence that it's on you to prove that you didn't commit domestic violence, which is not the way things work.
Yeah.
The burden of proof is on them. But I often feel like our clients, it's presumed that they're going to get a restraining order against them and that they have to come and bring their evidence and be the more credible party. And, some people just aren't good on the witness stand. They can be telling the truth and they come off as liars. That could be enough. Just the fact that you don't answer questions correctly, that you pause, or that you're so upset that you come off as aggressive and rude. And that's the one thing I've got to say is if you're facing a domestic violence restraining order case and you're up there with your arms crossed, giving gruff, monosyllabic answers, acting annoyed, the judge looks at your body language. He looks at your demeanor. And maybe you're rightfully angry, but if you're giving off those vibes, for lack of a better word, you can get a restraining order granted basically on that. So we've got to be so careful in the preponderance of evidence standard.
Well, one of our attorneys here, senior trial attorney Brian Mayer, we talked about being a witness and being a good witness, and he was talking about advising clients before you even step in the courtroom that you need to act like you're on the stand the minute you walk in there, when you're waiting for your case to be called, every interaction you have, because I think whether we like it or not, the judges see things, the court staff sees things, people talk. And so if you're frustrated, if you're angry, if you even look confrontational, I mean, we want to put all the chips, as many chips as possible, in your favor, because I would say that probably 75 to 80% at least of our clients, a temporary restraining order got granted against them before we go into the hearing. And that's, I think, what gives the feeling of you're fighting this uphill battle, because the judge already has a restraining order in place leading up to even your first hearing.
Absolutely. And if you think that judge works with that clerk every day and that deputy every day and that court reporter, and if you think that they're not going to let that judge know when they go back, when they're on lunch, or when they're on something else, do you think they're not going to talk about it if you're rude to them? I have some bad news for you.
I joke around and I say you'll know a good attorney when you have one, when they walk in and the court reporter, the courtroom assistant knows the attorney and they chat, because that means, number one, they're in front of that judge, they're in that courtroom regularly, but they have the positive rapport. And I think that's something that is very underrated. Sometimes we'll see criminal attorneys or other civil litigation attorneys come in to prosecute or defend these restraining orders, and they don't necessarily know the game.
And that's absolutely right. You'll notice when I go in, I'm always showing clerks pictures of my babies, right? And because it humanizes you, and by humanizing the attorney, it humanizes the client as well, right? So I think that's very, very important, and Brian's very smart on that, because it does start, it's even in the hallway, right? Because one of the reasons I always stick next to my client in a DV is I don't want them claiming that my client was staring them down or talking loudly and trying to intimidate them. I walk, and when I leave, even if we leave in a trial, I walk my clients to their car. Because I don't want there ever to be an issue where they're claiming that they tried to intimidate them in the parking lot. A lot of these attorneys that are prosecuting these, they fight dirty. They fight dirty, and they fight to win. And so you've got to be in there as well. You've got to go in with a good game plan, which we're going to talk about more on.
Yeah, and I think in the Bauer situation, I think what's really come to light, and this is something where, I mean, this man's worth 8 figures. He spent, we talked about before we went live here, if not hundreds of thousands, potentially even millions of dollars on his defense. Multi-attorney, multi-day defense of a domestic violence restraining order. Then he foots the bill to file a civil suit, and it appears went through thorough discovery, and this is something that's been going on for over 2 years. What came to light was it appears, or at least Bauer has stated, that the woman's first attorney had damning information that would have made her client look bad and failed to disclose it. Now, Bauer had all the resources in the world. He threw everything he had at this. It's not something that is practical for most individuals. So if you go into a case, and it's sad to say, I mean, we defend a good deal of restraining orders where I think they're just outright lies. They're trying to use the domestic violence restraining order process as a sword in custody. But what can someone do that maybe can't afford 8 or even 9 figures worth of discovery when you know there's this information that would prove you innocent? What are some strategies that you use?
Okay, so you have the right to all the discovery tools in your domestic violence case. So you have the right to take depositions. You have the right to depose third-party witnesses. You have the right to subpoena records. You have the right to subpoena. People always want to subpoena the texts. I've never seen that actually work. They don't really keep them, right? But you could presumably subpoena an individual's phone, right? Or make sure that they bring the phone to trial. But, I mean, you have subpoenas, ducis tecum, right? You have the right to subpoena businesses, third parties for any information that they have. You have the right to make them sit down and take a deposition. You have a right against parties for special interrogatories, requests for admissions, which again can be conclusive. And if they deny a request for admission that you later prove, you can actually get attorney fees on that as well, which is, I believe, a must attorney fees. If we look at Family Code 6044, the prevailing party, if it's the party bringing the attorney fees, it's a must. If it's the party defending, it's a may, right? Now, why is that? They don't want to have a chilling effect on people seeking domestic violence restraining orders. But I don't know. I think what's good for the goose is good for the gander, right? Yeah. But here's the elephant in the room. Mr. Bauer did not have a child with this woman. A child is not on the restraining order. And the crux where it gets really difficult is you get a spurious domestic violence charge against you. Your child's on there. So now you're going to go 21 days without seeing your child, unless for some weird reason they request that you have visitation on the restraining order.
And if you pursue discovery, you're going to get it continued out, and it's going to be even longer.
Correct, because, I mean, just for a basic subpoena, it's going to be up to 21 days, right? Deposition, if you want documents, we're talking weeks at a time. So you're looking realistically, and I in the past I have taken cases where it took us 6 minutes. It took us 6 months to get to a DV trial, right? Or even longer, because we were taking depositions, because we were subpoenaing records. We were having, if you have the money, having a PI go out and follow them or try to turn up other witnesses and additional information, right? But all of that takes time. And so usually we get that first 21 days. You have an absolute right to continue. But if you've got a child, now that means you're going to go 42 days minimum without seeing your child.
And depending on the county, they could set it out significantly longer.
Significantly longer, right? So that's the crux of this, because I've spoken about this before. One of my things I do is I answer ready on the first time, right?
And what does that mean? So walk the listeners through that.
So the court has to set, when they grant a domestic violence restraining order,
a temporary restraining order, yes.
Yes, a TRO, a temporary domestic violence restraining order. They have to have the hearing set within 21 days, right? Because basically you have been denied due process of law, right? Our whole system is built on having notice and the opportunity to be heard and to respond to your allegations, right? In every other case, the court does not like ex partes, right? They need to be based on immediate irreparable harm. But we have domestic violence that has its own rules, and they get granted and passed out like pieces of candy at Halloween, right?
The burden is so low. I honestly probably can count on my hands the number of times a TRO is denied with an attorney-written request.
Absolutely.
The bar is so low, and you know exactly what you need to do. And if you just you give them something a little bit credible, then you're going to end up with that TRO.
You have any allegation of physical violence, it gets granted, right? Any threat, even close, it gets granted, right? So that's the problem you have. So when we're going back to what we're saying, answering ready, you have the right as a responding party to one continuance. No questions asked. You want that continuance, you get that continuance. It's in the code, it's there. But again, you're going to wait another 21 days.
And the purpose of that is that 21 days is not much time. And so if you get served, and they can serve you with a restraining order as little as a week prior to your hearing.
Correct.
And so the purpose of that for everyone listening is that if you get served 7 or 8 days before your hearing, you have an opportunity to go out and get an attorney, for that attorney to get up to speed on the case. That's why it's so important. If you get served right away, which if they get the sheriff involved, you're going to get served right away, is to immediately hire an attorney. So like Ryan said, he can answer ready.
Right. Because why do we answer ready? Well, number one, if you haven't seen your kid, you get to see your kid faster, hopefully, right?
Yeah.
If you win. But we answer ready because a lot of times the other side expects you to continue, especially attorneys. They expect you to continue so you can catch them off guard. Their evidence is in the car. I've won cases where I knew they had evidence, but they didn't expect to go forward right away.
Yeah.
And so I answered ready, and they had their evidence in the car, or it was at home, or they didn't have 4 copies, or they didn't have any of these. Because, look, it's their case. They're supposed to be ready to go. If the court grants a continuance, and sometimes they're going to request it, I don't believe that's proper. Does it happen? It does. Much to my chagrin, it's happened a couple times. But the other thing is, if you know that their attorney has just come in, maybe they got the restraining order and then they brought an attorney in. That attorney's not ready either. And, I recently won a case against a very good attorney who had just come in the day before, and he didn't have all of his ducks in a row yet because he had just come in and they expected me to request a continuance. If I would have given that guy 21 days to get ready, he probably would have got the restraining order.
Yeah.
But he didn't have everything planned out because, again, he was just new onto the case.
Yeah. That's kind of the answering ready, the going forward right away is kind of one of those swords that you do have. I mean, I think of how many times probably by the time we get hired, by the time we get a substitution of attorney out, they're getting a substitution of attorney the week of or less than 7 days before the hearing. They're like, oh, we're going to show up and continue this. I've had them where I don't take calls from opposing counsel, and that makes them think, and I've had them where we've had secretaries be like, hey, they're really busy, and they're just, oh, this is definitely getting continued if they don't want a conversation. They walk up to you in the hallway at the courthouse, and they're like, okay, well, what are we doing? Continuing? What are dates? And it's like, no, we're moving forward today.
Yeah, put on your case.
Yeah, and they start freaking out. Those are the times where I've seen where the defending party may not even have to put on their case. If you jump on them, and you can get the judge to say you didn't meet your burden before you even have to defend yourself, those are huge wins.
Those are the best wins because your client never even has to stress out. So when you make that, it's a motion for non-suit, right? They haven't met their prima facie case for domestic violence within family code, and I'm going to bore you guys with some code sections, 6203 or 6320. 6203 is physical violence, sexual assault, or threats, imminent threats of immediate bodily injury. Mm-hmm. And then you have 6320, which is the laundry list of stalking, harassing, disturbing the peace of the other party, which is expanded. And we'll probably do a whole video on disturbing
breathing the wrong way in the same county.
Yeah. I mean, but there are limits. And I think we need to, it's important that you have an attorney that knows that disturbing the peace of the other party has limits. Right? It's not just like that they were unreasonably upset. It's more from an objective standard that no person should have to deal with that. Were you at their house pounding on the door for 3 hours saying, let me in? Like, that could disturb someone's peace or trying to get into their house. Yeah. It's far different from them saying, well, he's stalking me because he kept showing up at the OBGYN appointments that I told him about. Right?
Yeah.
Which can be a thing. So answering ready can be a very good tool, but it's risky.
Yeah.
Right? Because you haven't had time to go through the ins and outs with your attorney. You probably didn't get time to really go through a mock run on how to testify. Right? So it is risky. It is risky.
I mean, give it the sports analogy. It's football season right now. I mean, you see the no huddle, hurry up offense. Well, the defense isn't ready. You may not be fully ready, but the defense is still scrambling around, and it gives you an advantage. Right. But there are definitely cases where you say, hit the brakes. let's line up. We have a better case. We have better players than they do, and you go best against best. So it's a balancing act. And it's definitely something that an attorney who, I mean, I would say our firm probably defends more restraining orders than any other firm in California at this point. But it's an attorney that can judge whether, hey, we want the hurry up offense. Let's push this through. Maybe we got some bad facts that we can slip through versus our case is just flat out better. Let's get lined up and let's just shove it down their throat.
100%. And the ones that worry me, let's be clear here. If you've got witnesses on the other side, and you either, one, know what they're going to say, but you need to try to find bias or anything else, or you have no idea what they're going to say, that's a danger point right there, right? Yeah. Because when we've got a he said, she said, you bring in one credible witness, if you bring in one credible witness who calmly says, yes, I saw this, and explains it, the judge is going to side with that witness. Right? A lot of times the judges will, in a recent one I had, found my client not to be entirely credible, found the opposing party not to be credible, but found the mother to be entirely credible, right? Now, she had another witness as well. And so the witnesses were basically arguing, and they found my client's mother to be more credible. So, if sometimes you're going to need to depose those witnesses. If we're really, like you're saying, we're lining up and we think we have that strong case, they say in law school, never ask a question that you don't know the answer to.
That's the scary part, because any other area of law, if you go employment, civil litigation, criminal, you know exactly what everyone's going to say before they get on the stand. I would say 95 times out of 100, you don't know exactly what they're going to say because, depositions are expensive, discovery can be expensive, things need to move fast. It's a different area of law. I think that's the scariest thing we probably get used to as family law attorneys that other areas of law find crazy. I was talking to an employment attorney in Orange County last week, and we were talking about it, and we had actually done a deposition in our office, and it was the first time in several weeks, probably a couple months, that we had done a deposition in office. They have 3 conference rooms that are in use every single day doing depositions.
Right. Absolutely. 100% on that. And throughout my career, I know early in my career, one time she basically was going after him. There was physical violence as well. But she said there was on the restraining order the cat, and that he was rude to the cat and he was mean to the cat. And so I said, isn't he true he's an animal lover? And she said, no. And I said, well, what leads you to believe that? And she said, well, he killed my cat once. And I looked at him and I said, what? And he said, that cat attacked me first. Right? It did not go well for us after that. On the record. That's not in deposition. This is in court.
Oh, that was in court.
In court. Yeah. So, no, and in the same case where she said he's an alcoholic, and I said, objection, impermissible lay testimony. You're not an expert. You don't know. And so the attorney goes, okay, cool. So how long have you been with him? For 15 years. Do you ever see him drink? Every day. How much does he drink? He drinks a case of beer a day. Right? Far worse. Right?
Be honest with your attorneys.
Yes, be honest with your attorneys. But it's like, again, if you haven't taken the deposition, you don't know exactly where they're coming. Now, again, we always want to try to stick. If they try to go beyond the charging allegation, the domestic violence 100, we want to try to stick them to
Four
that.
corners of the paper.
Exactly.
Don't let them get off of it.
Exactly. But if you open the door and you ask a question beyond that and they answer, that's on you. And so that's, again, that's the danger we have in going forward without knowing what that witness is going to.
Yeah, and I think it's something you are a master of. You talk about it, a lot of times restraining orders end up being credibility contests. Who is the most credible? What can the judge believe? And I think one of the best strategies is it's just human nature. You're not going to be able to remember anything and everything. And so going line by line and making them recall it in kind of a next level of detail.
Absolutely. I mean, that's, again, I want to know what time of day it was, what was the lighting, what was the aspect. Again, we've done well in showing that where they say they were standing to see something that they couldn't possibly. So we've introduced photos from that aspect showing that. So anything that you can do to throw it down, because it's so easy, and I've seen them granted where they just say, well, we were in the room and he choked me. Okay. Where were you? Where did he start? What hand, right? We want to know that. Now, can that actually make their case better if they're a good witness? You can, because, you could argue if they've just made that blanket statement, well, look, they didn't provide any details, right? It's just this simple one. And so in trying to get beyond that, you can actually make their case better. So that's a risk as well, right? Because if they're really good, and it's okay, if they're really good at it, maybe it means it was true, right? There's that possibility.
You can also win on irrelevant facts.
Yes.
So they include facts they don't necessarily need to include in their restraining order, and they're not domestic violence, they're not germane to the issue, but when it becomes a credibility contest, I've had situations where one of the allegations was that he drove past her house. They'd been divorced for over a decade. She always picked the kids up and dropped the kids off at his house. She was claiming that he drove past her house. That's all she said. That wasn't an allegation of domestic violence, anything like that. I feel like I won that case because we showed records. He was a truck driver, that he was in Salt Lake City, Utah, when I started asking her for details. And it wasn't relevant to her actual allegations, but she had flat out lied. So I found that's the safe one to go, is if you have those irrelevant facts that they have offered up.
Oh, absolutely. Because if they lied about that basic element, right, what else are they lying about? That is, realistically, if you can pick around, because it's like, especially if there's multiple witnesses, they have their core story, but there's elements around it that they haven't discussed, that they haven't talked about. They haven't circled in, they haven't circled the wagons on that. So they're going to have the basics down if they're telling a lie. It's the outside facts where you can trip them up and then cast doubt on the story itself.
And that's a big one. You talked about having an attorney or not having an attorney. Is a lot of times restraining orders, these are the only court documents that somebody will help you fill out. Is a lot of times people will go up and they will fill out the domestic violence restraining order packet by themselves, and they will put irrelevant facts. They will leave out things that are relevant, and you can keep them from bringing those up, and then you can make them look bad on the irrelevant stuff at really minimal risk.
100%. The one I always, when you catch them on that and they say, oh, well, the person that filled that out filled it out wrong. And so that's where you have to stop and go, okay, is that your signature at the bottom of that page? Yes. Yeah. And do you have the capacity to read? Right? I don't say that. But is that your signature? Right? So you went over this document, right? You can't let them get away with, oh, that was just a mistake that the person who prepared it, right? Because that's the one I keep seeing a lot lately is, oh, well, I didn't know what I was doing. I didn't know this.
I haven't been to any of the courthouses and watched or been to the clerk's office. Used to, they couldn't fill out the documents for them. They'd do the packet, they would check it, and then they'd send you back out in the hallway. Mm-hmm. So that's an interesting, I guess, development.
Well, and I don't even know that it's true. I think you really need to grind them on that process. But
irrelevant fact that you really have no risk of pushing them on.
Right. And and if they don't have an attorney, because sometimes I'll go down that rabbit hole because I feel like something's off there, and a good attorney will start being like irrelevant, but it's like, you know what? Again, they opened the door, right, by bringing in that irrelevant fact. So I have the right to question them on that fact. I do think that's very important because, again, you can score and you can win based on these irrelevant facts, right?
Yeah.
And sometimes you don't even know the context of it before you get into it. That's, again, the difference between teeing everything up, going full out, doing the discovery, which, again, is expensive. If you're going to, now again, a lot of these depositions, if it's a third party, they don't take as long as, say, another one. But when you've got a long relationship and maybe, they're trying to bring in 10 years of, he was rude to my cat 10 years ago. And then he accidentally swung something or hit me with a baseball when we were playing catch with the kids. Right. Yeah. And it says it. You can conflate a lot of small issues and try to bring in a pattern of abuse, right? Because that's disturbing the peace of the other party that allows you under the newer definitions to introduce a pattern of conduct that destroys your mental or emotional calm.
Yeah,
right?
feels like every year we get additions to the 6000 series, the Family Code, the DVPA that expands that definition.
Isn't it? And I would like it to be shrunk, but it keeps going larger and larger. They've added in threatening immigration status as domestic violence as well, right?
Which is completely irrelevant in family court for anybody out there.
Yeah, everyone likes to throw that in that, well, they were dishonest because they are an illegal immigrant. It's not going to go anywhere. It's just not. If you want to go down that path, you just see what happens. It's the courts are not interested, especially in California. I don't know about maybe some other state that's a little bit more red or something like that, but in California, you are not going to get anywhere.
Well, it's statutorily.
Yes.
So statutorily, it is irrelevant. So most judges will just cut you off.
Yes.
Right then and there, because we've had it on the other side where they try to bring in the fact that say it's relevant that this person's undocumented.
Right. And the other thing you've got to worry about is when you're trying to put on your case, a good attorney is going to be objecting against us that the things we bring up are irrelevant. Right? That your reputation for being a nice guy or for, there's various other things. They don't want you to tell your story, right? Yeah. And so they're going to pepper you with irrelevant because the judge and your attorney has to fight for you and say, no, this is relevant because it shows X, Y, Z. But you have to have a plan because these judges want to go home. They do not want to sit all day in a court case, right? So the judge will tend to want to limit it to the specific instance that's alleged. All I want to know is, did domestic violence happen on Tuesday, March 27th, right? And so when you start talking about what happened on March 26th, you're going to get an irrelevancy objection, and you have to say, oh, no, this shows motive, this shows bias, right? We have to already have that tied together. And so if you're a pro per in propria persona, right, you're in there by yourself, a good attorney a lot of times is going to limit what you get in because you're not going to be able to articulate yourself, right? You're not going to be able to say, well, look, Your Honor, she says that we did this, but on the 26th, she threatened me, or she said, you know what, if you don't shape up and act right, or if you cheat on me again, I'm going to bring a domestic violence against you, right? Yeah. So, again, you need to be able to push the judge and not let them limit your defense.
Yeah. No, I've definitely seen where it's attorney defending against pro per, and the pro per, they don't get anything in. They get to tell a little bit of their story, but everything else stays out. The attorney looks up at the judge, kind of shrugs their shoulders, and do we need to go any further?
Right, and that's where you make your motion for non-suit. I mean, I remember one time, it was years ago, but I think I had like 22 straight sustained objections, and then the other side just gave up and dismissed it, and we all went home, right? Because, if anything else, I could pass on. If you do make the mistake of representing yourself or you don't have the money, anytime you hear someone say, he said, just say here, objection hearsay. That's a tip we'll give you. Now, there is more in the rule because most times party admissions are allowed in. I'm not going to get into the weeds of which party is bringing it and some of the other rules. But generally speaking, if you said it and it's being used against you, it's going to come in, right? So just remember, people, your text messages, your social media, all of that stuff, it will be used against you, right? Absolutely.
She's keeping receipts.
Mm-hmm. Yeah, guys, and I do remember this. I mean, I had a case recently. Well, I don't believe he choked her, but she said, well, he choked me a year ago. And then there's corroborating text where she's accusing him of it, but he denies it at the time, right? But I don't know. Was she smart enough to basically set this up and tell other people, family members, hey, he choked me, and then they come in and testify and say, yeah, she choked him. Now, again, I objected for other reasons here. We're not going to get into an evidentiary code case right now. But you've got to be so careful. Your actions and your words will be used against you. They will be
100%.
used against you.
100%. And on that, thank you so much, Ryan. So much great information to listeners and viewers. To everyone, if you're listening, watching, thank you for supporting the channel. And we'll be back with you next week for another episode of the Father's Rights Playbook.
What's going on, guys? It is Mark Reel Jr., the Father's Rights Attorney. And on August 7th, I am releasing my first book, The Father's Rights Playbook. My introduction to family law was my own family law case and going through the family court system. And in doing that, my eyes were open to the injustices that occur and the trials and tribulations that fathers are put through. So it was a personal experience, and then my eyes were open to this broad systemic issue, which has inspired me to build this firm and